People versus Martina Smith.
The water assistant prosecutor. People.
That's
Good afternoon. May it please this honorable court, Kareem Johnson, been on behalf of Martina Smith, who's approaching to my immediate right.
your name?
Martina Smith.
What starts as a routine request for an adjournment instantly turns into something far more serious. This isn't just about scheduling anymore. This is about trust, legal strategy, and a defendant who believes her own lawyer is working against her. Accusations like that can derail a case fast, and the judge is clearly not buying it. Stay with us, because this hearing is about to expose how refusing sound legal advice can put a defendant in far greater danger than the original charges ever did.
And what are we doing?
Your Honor, the defense is requesting an adjournment in this matter. There's been a breakdown in the relationship between me and Ms. Smith. She is seeking to retain private counsel.
Didn't she, other than the public defender, didn't she have an attorney before you? Or no?
No.
Okay. Maybe I'm thinking of a different case. All right. Ma'am, what seems to be the problem?
I just don't feel comfortable.
I don't know what that means. Okay.
Well,
Your Honor, she believes that I am working with the prosecution. I've tried to explain to her.
Excuse me? Oh, no, go ahead. I want to hear this.
I've explained to her that under Michigan's R&O statute, there are 7 different ways that you can obstruct an officer, including just talking back or ignoring the officer. We've had an agreement for HIDA. I thought we had that agreement worked out. She had me speak to an individual who I believe was her father, who indicated that he was a paralegal, and gave me his MDOC number and instructed me to actually hold the exam and let you bind it over. I refused to do that because I believe the prosecution will be seeking to add an additional at least 4 counts of R&O for the other officers that were there. And I told him that what I would do is I would ask for an adjournment because having additional charges added plus walking away from an agreement where she would have no record, her should be in 25. So she needs the prosecutor's consent for HITA. I felt it was best for her to just get somebody that they feel more comfortable.
Well,
This is a critical legal moment that many defendants misunderstand. Under Michigan law, resisting or obstructing an officer isn't just one charge. It can multiply fast, depending on the number of officers involved. What the defense attorney is describing here is damage control, avoiding a preliminary exam that could open the door to additional felony counts. The irony is clear. The attorney is trying to protect the defendant, while outside advice from someone who hasn't reviewed body cam footage is pushing her toward a far riskier outcome. So here's the question. If your lawyer is warning you about added charges, do you listen or do you gamble?
okay, so first of all,
you never said nothing about the
no
charges.
down to the one. And what?
You never said anything about adding charges on her or nothing at all. That's not true.
See, here's what
I didn't.
I'm a bit concerned about. Because now you're going to try to overtalk me. Go ahead. I'll wait. You done? Are you done? So first of all, I think, because I've watched this attorney in my courtroom various occasions doing two Yeah, I don't know how he stands there and not take offense when you're saying he's working with the prosecution and forsaking his client. Because this man would never do that. Ever. I mean, I that's what I just find kind of just crazy. And if he really thought it was in your best interest to have the exam, there is not a doubt in my mind he'd hold the exam. So that's the first thing. And I was right. This is now the second attorney. Because it's my staff with me. I was looking for the paperwork. You had Mr. Elman. And you basically had that same complaint. You don't get to continue to choose attorneys. So I guess part of the problem is going to be this is set for preliminary examination. And I understand that part of the reason that counsel is asking for the adjournment is really to save you. I am almost of the mind that you don't want to take his advice. You don't want to do whatever. Let's hold the exam. If you get charges at it, you get charges at it. That's your call. But I'm not removing him from the case. So now what do you want to do? Because we're not going to play this game.
This is where the courtroom dynamic shifts completely. The judge draws a hard line and reinforces a fundamental principle of the justice system. Defendants do not get unlimited do-overs with court-appointed attorneys just because they dislike legal advice. The court recognizes a pattern here. Repeated complaints, repeated attorneys, same objections. From a judicial perspective, this isn't about personality. It's about procedure, efficiency, and preventing manipulation of the system. The warning is unmistakable. Ignore counsel, proceed with the exam, and accept whatever consequences follow. Would you take that risk if multiple felonies were on the line?
Your Honor, may I?
Yes.
Because of the conversation that I've had with her father, I'd humbly ask the court, if the court's not going to remove me, to just grant a brief adjournment. I've never asked this court to remove me from a case.
I know.
But we have somebody who has not looked at the body camera footage, advising his daughter on what to do in a criminal case in which she could walk away with multiple felonies. So I understand the court's frustration. I understand the court wants to move in the docket, but this is not her request. I am asking for, at the very least, an adjournment in this matter. So ultimately, she can have counsel that they feel confident in and make a decision that is not going to negatively affect her.
Well, people have a position regarding adjournment.
We do not, certainly no position regarding her counsel. People do not object to an adjournment, Your Honor. People release the witnesses because we were under the impression that an agreement had been reached, and then that fell apart. So you could, and then get the officer back if the court orders to do that. But under the circumstances, we would not object to an adjournment.
I'll grant the adjournment. I can give you, because it's got to go before me. I can give you next week or the 13th, I think is.
What day next week, Your Honor?
The 30th. It'd be Tuesday next week.
That's fine, Your Honor.
That'll work.
Yes, sir.
Preliminary examination in this matter will be adjourned December 30th, 2026. 9 a.m. That's at 12 noon. That's before me.
Yes, sir, Your Honor.
Ma'am, I'm just going to give you a fair warning, and I mean, I'm not playing this game with you and the attorneys. Either you're going to listen to them, or you're going to have an exam, and then the chips are going to fall where they may. If there are other charges and other things added, that's just going to be too bad for you. But if you think that man sitting next to you isn't trying to save you and put you in the best possible position, well, that's your fault. You know, because apparently with your law degree, whoever else with their law degree knows more than he does.
In the end, this case delivers a powerful lesson about courtroom reality. The judge grants a limited adjournment, keeps counsel on the case, and makes it clear that future games will not be tolerated. The ruling underscores a broader truth. Legal strategy is about foresight, not emotion. Accusing your own attorney, relying on unqualified advice, and rejecting experienced counsel can turn a manageable case into a disastrous one. If you found this courtroom exchange as intense and revealing as we did, hit the like button, share your thoughts in the comments, and subscribe for more in-depth, no-nonsense courtroom breakdowns you won't see anywhere else.
Bond will continue.
Thank you.
Hit my door. No, she hit my door. Huh? It was soft? No, it wasn't. I heard it. What are you trying to say? No, okay. That's fine. I'm not going to make you chase her down. I'm just going to. You do the same. Happy holidays. Okay, in the Christmas spirit, they go. But then that's it. Somebody else do something. That's it. I'm not even looking for your suggestion. Just don't be an order. Court calls the case. People versus Nathaniel Bryce.
People.
Judge Postic on behalf of Mr. Bryce.
Your name, sir?
Nathaniel Bryce.
Thank you. Is this going to be as complicated as the last case?
No, Your Honor, I expect a waiver.
Oh.
Her expectations we met, Your Honor.
So he's waiving.
He is.
Sir, is that correct? You're waiving your right to a preliminary examination?
Yes, Your Honor.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed.
Yes, Your Honor.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive their right.
We do, Your Honor, exchange for this waiver, there will be an offer available to the defense of plead guilty to count one, attempting, resisting, or assaulting a police officer, causing injury, with dismissal of counts 2 through 4 and sentencing under fire.
That's your understanding.
That is my understanding.
Defendant is bound over to circuit court on counts 1, 2, with 3 and 4 following. Counsel, you acknowledge receipt of the information and waive it.
Yes, I do.
And how does your client plead?
Not guilty.
All right. And if pleads not guilty as to all 4 counts, court will enter that plea. Pre-trial in this matter will February 12, 2026, 1:30, for Judge Slee. And we'll continue.
Thank you.
Thank you. And happy holidays to you.
Same to you. Yes, you are. May I approach in a separate matter?
You may, sir. Do all this stuff myself. Almost had to chase a defendant now. Myself. Court calls case, People versus James Thompson.
What was the name, Your Honor? I'm sorry.
Thompson. Did you think I was calling your client? No.
As an officer, people.
Assistant Public Defender Chelsea for deals with and on behalf of James Thompson. Please state your name.
James Thompson.
Thank you, sir.
Good afternoon, Your Honor.
Good afternoon.
Your Honor, sitting in for 88 and at this time people are unable to proceed.
I would move to dismiss.
People being unable to proceed in this matter.